I think the point of having these requirements is to avoid selling to minors, including those who look older than their age. And there's a lot of 17-year-olds that can pass for 18. So rather than create an ordinance that only requires those who are under 18 to be asked for their ID, I would hope that the retailers would think, boy, we better be asking people, even if we think they look like they're 18 or 19 or 20, we better ask anyway. I know that I was carded for alcohol well into my 20s, and that's because people didn't want to run afoul of the law. Thank you.
Thank you, Mr. McCowan. Others wishing to speak to this item from the public, please. Okay, seeing no one, I'll bring it back to the board. Supervisor Smith.
Thank you, Mr. Chair. I think that staff has done quite a good job in sort of trying to rectify some of the inequities here and some of the areas that were confusing and make it a better ordinance for everyone involved. The only major issue I think I've heard today is this concern about would it be appropriate to have fines linked to amount of sales? And I don't know if that was considered when you did this in-depth research, so maybe you could comment on that. And then if that was the will of the board, is there any easy phrase we could put in? I mean, there could be something, I was just thinking in terms of when you're talking about fourth violation, this is a fourth violation, a 36-month period that ranges from 10,000 to 20,000. I mean, you could just put a phrase in each of these sections on the various violations that would say consideration of volume of sales to be a component of decision on fine. I mean, perhaps maybe that's one way to cover it if that's the will of the board. But otherwise, I think it maybe is not perfect, but I think it covers what we need to do, and it's an improved ordinance, and hopefully it will be more effective, and it will result in more education and giving sort of that impetus to retailers to embark on more serious educational efforts with their employees. Thank you.
Thank you. Supervisor Pinches.
First of all, to address the issue of the amount of the fines, there, if you look at how the stage one or the first offense, the second offense, there is some flexibility through the hearing officer on what the fine will be imposed. So, for instance, the second licensee, it goes from $1,500 to $2,000. But to get into the fines are for the violation. You don't go down the road and get a speeding ticket and the officer asks you, well, how many miles you got on that car? Or is that a Cadillac or is that a Volkswagen? Depending on what your fine's going to be. The fine is for the violation. It's not about how much money or how little money you have. Frankly, I don't think it's much of anybody's business how much a retailer does in gross sales or anything, or how much he makes, or if he's driving a Cadillac or a Volkswagen. I don't think that's a function of government. So I support, there is a fluctuation in the fine amounts. It's not dead set number. There is, if you look at from the second offense on up. So I support the ordinance. I think there's been a lot of work on this. I think that as county council has said, this issue is, our county council has also been working on this for a long time. Some of the retailers have come forward and certainly help get it to a close, and I appreciate that Mr. Gavere drove all the way down from Laytonville to express his basic support. As a person that's been a retailer and was over 40 years in the Laytonville area and held a lot of liquor licenses and whatnot, it always bothered me that the owner of the facility, whether it's a liquor license or selling out or tobacco, always got the brunt of the penalty. In other words, all the penalty. It would be kind of like you drive down the road and you get a ticket, and they send the ticket to the bank that financed your car because it was a real owner. And that's what happens with these ordinances. It's the owner of the business takes the full brunt, and the person that actually does the violation gets off pretty much scot-free. I guess you can fire a minimum wage worker, but that's not going to probably affect them much. But so it puts all of the real penalty on the person that owns the building, the business. And sometimes, you know, you can do training and you can teach your employees and you can reprimand whatever, but the fact of the matter is people make mistakes. And when you're in a counter and there's 15 people lined up to get their gas or get their potato chips or whatever, and you're a clerk up there, I don't care who you are, whether it's me, it's had years experience doing it, or a person that just went to work last night, there's the pressure of servicing the people. So sometimes maybe you get in rush, and maybe you don't read that ID as good as you should, and you do make mistakes, you know, and this gives a little bit of a leeway for the owners of the business to where, you know, they get a chance to state their case. And it's, you know, we take it serious. And we've done a great job of reducing the amount of tobacco use, but it's, I support this ordinance. I think it's come a long way.
Thank you, Supervisor. I too have a concern of maybe separating the penalties, either fines or penalties, due to the size of the business. Okay. I'm not quite sure that would hold up in court if we had that separation for different levels of success, for lack of a better term. In regards to item F, the youth decoy description, reasonably appears under the age of 18. I'm quite envious that someone would have that opportunity. I was never granted that due to